Welcome to The Verdict. Kent Meyers and Mick Cornett joining you again this morning with a brand new show talking about Native American law. Mick, good to see you again.
Good to see you as well. And of course, there's more discussion going on than probably any time in recent history about the federal government, the state of Oklahoma, and Indian tribe rights. And so I think this show is very timely.
Yes, I don't know that there's a state in the union that could be more affected by a couple of Supreme Court decisions that we've got a real expert to tell us about today, dealing with the rights of the tribes in Oklahoma versus the state of Oklahoma. We've got Mike McBride, a real genuine expert in that area. And I say that with pride because he's a partner of mine in our Tulsa office. And we're going to be talking about Native American relations with the government. Looks like they're askew again.
Looking forward to it. It's all coming up today on The Verdict.
Well, let's take a break.
I have found my passion in history by encouraging other students to learn about their own history as well. My name is Ellen Brooker. I'm a social studies teacher, and I am Chickasaw. I'm very passionate about teaching about my heritage and being Native American because I want students to look at their heritage to understand that what's in the textbooks is just perspective. It is everything that is cut down to fit into one book, and it doesn't tell the whole story. It's so wonderful when you see the light bulb go on and they actually get it, and they're excited and I'm excited, and it makes all the difficult days worthwhile.
See more stories about the Chickasaw people at profilesofA.nation.com.
One of the best kept secrets about the post 9/11 GI Bill benefit is that it can be used at a trade school or a technical school, and it doesn't have to be used at a university or college. These are benefits that the veterans have earned through their service, and they should take advantage of it.
Veterans really need to understand that there are many resources offered by the Oklahoma Department of Veteran Affairs. They're there to help you find the right school for you, the school that will help you and your family make great steps into your future.
And welcome back to The Verdict. Kent Meyers and Mick Cornett joining you again this Sunday morning, and whenever it is you're watching this show on YouTube or otherwise. We indicated in the introduction that we were going to talk about Native American law and the relationship between some tribes and the Oklahoma state government and the U.S. government. My partner, Mike McBride, is our guest today, and Mike is chairman of our firm's Native American and Indian Gaming section. He did his undergraduate work at Trinity University, did his law work at the University of Oklahoma. He has had, since being a very young person, a real interest in Native American matters as growing up in the eastern part of the state. He, for 25 years, has accumulated vast experience in this area through teaching, through practicing. He has represented as general counsel to Native American tribes. He has represented as attorney general to more Native American tribes here in Oklahoma. He's practiced, taught, and lectured about Native American law in Oklahoma, in the United States, and frankly, in other parts of the world. Mike, really glad to have you. It's sure good to see you.
Thank you, Kent. And congratulations to you and Mick on this 995th edition of The Verdict.
Thank you.
Yeah, and Mike, Native American law is such a specialty. How did you get interested in that?
Well, I grew up around Bartlesville, and my grandparents were from Fairfax, and my grandmother was actually born down near Geronimo before Oklahoma became a state in the the Comanche, Kiowa, and Apache Reserve. And I've always had a fascination with Indian art and culture. And during law school, I clerked for the Court of Indian Appeals and also interned for the Oklahoma Supreme Court for a justice that had a great interest in that area, Justice Yvonne Cogger, the godmother of the Sovereignty Symposium. And I really focused my career in practicing in this area.
Mike, let me ask you, you mentioned something that I would like for you to talk about just a little bit, particularly with Justice Cogger's relationship to it, and that is the Sovereignty Symposium. Our viewers may not be familiar with what that is. Could you tell all of us a little bit about it and how important it is to Oklahoma?
The Sovereignty Symposium was started and sponsored by the Oklahoma Supreme Court under the direction of Justice Yvonne Cogger. It has a not-for-profit status, and it has a board of directors, and I believe it is now in its probably close to 40th year. It's happened every year. It started in Guthrie, Oklahoma, then moved to Oklahoma City. It's been in Tulsa for a number of times, and then back to Oklahoma City each summer. It's usually in June. It's usually right before Red Earth, the native event in Oklahoma City. And it brings together tribal, state, and federal leaders, lawyers, and judges to talk about issues of importance and mutual interest. It's a non-adversarial kind of symposium, and it's been really wonderful for tribal state relations and scholarship in the area.
Well, it's world renowned. I know that. It's known that folks come to that Sovereignty Symposium from everywhere.
Unfortunately, with so many things, including this program, COVID-19 has had an impact on it, and it's been canceled this year. So we'll have to look to 2021 for the next Sovereignty Symposium.
Yeah. Mike, what is the case that's taking place now that the Supreme Court is reviewing? Can you give us kind of the basic ideas behind what the court is trying to decide?
Happy to do so, Mick. And it's not just one, but it's actually two cases that are related. The first that has gotten all the attention is Patrick Dwayne Murphy against the warden of Oklahoma. And that name keeps changing. When the 10th Circuit decided that case, it was Murphy versus Royal. Then when it was argued to the Supreme Court in November of 2018 for oral arguments, it was Carpenter versus Murphy. And now it's Sharp versus Murphy as an interim warden. The other case is Mcgirt versus Oklahoma. And let me talk about Mcgirt first.
Spell Mcgirt for us.
MC capital G IRT.
Thanks.
Mcgirt. And Mr. Mcgirt is a Seminole citizen who resided in Broken Arrow, a suburb of Tulsa. And he was tried and convicted for sex crimes involving lewd molestation and other serious crimes involving one of his adolescent relatives. And he was convicted, sent to prison by the state of Oklahoma. And in the wake of the Murphy decision, which was decided by the 10th Circuit, he challenged his conviction, claiming that Oklahoma didn't have jurisdiction over him. He claimed that his crime actually took place within an Indian reservation, and that actually it happened within the Muscogee Creek Reservation, and it was not disestablished by Congress, and therefore the Major Crimes Act, which is a federal criminal statute that grants exclusive jurisdiction to the federal government for crimes against Indians or Indian perpetrators for major crimes. That only the federal government could try and convict him, not the state of Oklahoma. So that's.
Well, let me ask you a question. You said it was the tribe had not been disassociated. What are you talking about by disassociated?
Well, disestablished means
disestablished. Excuse me.
Yeah, disestablished is a term, a legal term that the Supreme Court has adopted in a number of different cases, where they say that Congress has to use very specific language to show its intent to break up the reservation, that a reservation no longer exists. And there are several cases that the Supreme Court uses as a test, and they're fairly recent. One is called the Solem versus Bartlett, a 1984 U.S. Supreme Court case. And following in its footsteps just 3 terms ago is Nebraska versus Parker, or Parker versus Nebraska, which is 2016, decided by unanimous Supreme Court. And it laid out a test for what the Supreme Court looks for to determine whether Congress actually intended to dissolve the reservation or not. And basically, Mr. Mcgirt and Mr. Murphy claimed that the Creek Nation was never disestablished, that Congress didn't use the proper language to disestablish that reservation, and therefore it still exists. And that has potential wide ramifications for civil jurisdiction and also criminal jurisdiction. So these issues are pretty weighty, and it could potentially impact 5 of the major tribes, the so-called 5 civilized tribes, which are the Cherokee Nation, the Choctaw Nation, Chickasaw Nation, Seminole Nation, and the Muscogee Creek Nation. These particular cases focus specifically on the Creek Nation reservation, though, and whether that was disestablished. The Mr. Murphy also makes the same arguments, except Mr. Murphy has much higher stakes. He's currently on death row down in McAllister, held by the state of Oklahoma. And if he can get his conviction set aside, he certainly won't go free, most likely, but if he's tried by the federal government, he will not face a death penalty, because the Creek Nation under the Major Crimes Act has not opted into the federal death penalty.
Mike, at that point, excuse my rudeness for interrupting. We need to get to a break. You're watching The Verdict with Mike McBride. We'll be right back.
OU Law has a history and heritage that are unparalleled. At the University of Oklahoma College of Law, we empower our students to pursue the career of their dreams. We have the highest U.S. News ranking ever achieved by an Oklahoma law school. We are the first law school in the country to launch a college-wide digital initiative. And this year, our competition teams rank number 2 in the nation. OU Law, generations of excellence, limitless possibilities.
The good life comes naturally to Tulsa, where nature's beauty is matched with an eye for aesthetics. A legacy of neighborhoods graced with lawns and landscaping and handsome homes. A place that seems to have patented an ideal lifestyle. Bank First is loyal to the quality of life Tulsa assures its citizens, to the priority placed on education, culture, and growth. Loyal to builders who transform raw land into residential charm. Developers who see opportunity and add vitality to Tulsa's economy. Bank First serves both enterprise and private lives that need a loyal partner. It's how we help nurture this city's very good life. Bank First. Loyal to Oklahoma. Loyal to you.
Welcome back to The Verdict. Kent Meyers with Mike McBride and Mick Cornett were talking about the tension between some of the tribes in Oklahoma and state and federal governments. Mike, you were talking before we went on the break about the Supreme Court cases. Let's take a look at a map that will give our viewers at least a little idea of how much of Oklahoma could be affected by this decision. Can you describe by color, since our viewers will see the color on the map, which tribes are affected and how much land, just approximately how much land area in Oklahoma is impacted?
Happy to do so. Is that map up now?
Yes. It's up.
Okay. We're basically talking about the eastern half of Oklahoma. It is roughly 19 million acres. It's the Cherokee Nation, which is in orange. The Creek Nation, which is in yellow, which is, I think, 11 counties. The Choctaw Nation, which is in green in the lower left-hand corner of the map. The Chickasaw Nation, which is in red in the lower western part there. And then the very center, Seminole Nation, which is coextensive with the Seminole County. Mm-hmm. Well, it's roughly 1.8 million people that reside in that area.
Well, it affects all of those people, Mike. But I'm wondering, what do the tribes think of this? Have they expressed an opinion on the effects of the Supreme Court decision? Have they kind of played their hand before about how they would react?
The tribes have definitely weighed in. The Muscogee Creek Nation was allowed to submit briefs and argue at the Supreme Court. And others have filed what are called friend of the court briefs, amici curiae. And the points that they make is that things are not going to change that much. There are cooperative state agreements that are very common on issues of mutual interest between Oklahoma and the Indian tribes. For example, we have a number of compacts on cross-deputization agreements where tribal police and state police agree to share jurisdiction and law enforcement powers. There are water agreements. The city of Oklahoma City, for example, has worked out an agreement with the Choctaw and Chickasaw nations over water. There are license plate agreements. There's tax agreements. There are agreements involving tobacco. Just a multitude of issues can be handled by these cooperative agreements. And
what about criminal jurisdiction?
Criminal jurisdiction is really the big issue in this case. And given the Major Crimes Act, if an Indian perpetrates a crime within a reservation or is a victim, then there could be federal jurisdiction if it's under the Major Crimes Act, which are a number of real serious crimes. And the U.S. Attorney's Office and the FBI would be involved in investigating and prosecuting those in federal court. But there's also concurrent tribal jurisdiction. And the tribes would also have jurisdiction to prosecute. And they would pick up the bulk of the minor crimes against Native Americans. And for tribes that have, many tribes have their own court systems. And for example, the Muscogee Creek Nation has a very robust and well-funded, well-respected court system. And under the Indian Civil Rights Act, if they provide the constitutional protections, they can impose fines up to, I believe, $5,000 and up to 3 years in jail for criminal offenders that are convicted in that system. There's also the Violence Against Women Act, which provides that if there's a non-Indian perpetrator that lives on the reservation and is in a domestic relation with a Native American, and they're involved in certain crimes of violence, and they could be tried in tribal court under federal law. And that's existing law that's currently on the books now.
What about law relating to children in a little different context. I'm aware generally of the Indian Child Welfare Act that allows tribes to have a say-so or perhaps exclusive jurisdiction over placement of a child as between parents and others. Would this have an effect on that?
The Indian Child Welfare Act does provide preferences, and it tries to uphold the connections between Indian families and who had been wrested apart over time. So these cases could have a potential impact on ICWA, as we call it.
Yeah.
But generally, the tribes work really closely with the Department of Human Services to place children and look after the best interests of the children.
Mike, when do you think the Supreme Court will make a decision on this issue?
You know, this has been a really unusual time with COVID-19 pandemic. And for the first time, the Supreme Court heard oral arguments. And this was one of the cases on May 11th when they heard the Mcgirt case, that they did it telephonically. They took about more than a month hiatus on hearing oral arguments. And typically their term, it's called an October term, and it starts the October of the previous year and then ends the following September 30th. But typically, by custom, they will finish their business by the last or the third or fourth week of June, and they typically release all their decisions by then. But given this unusual circumstance, I could see that this case might get pushed off a few weeks into July, particularly given the blockbuster nature of this case. And I might add that the Murphy case was originally argued in 2018. In, I believe, November 27th, I attended the oral arguments, and they asked for additional briefing, which was highly unusual. There's only been a couple of cases ever for that to happen. And they waited until the last day of the term, which I believe was the third week in June of 2019, and said that they were going to push this case for re-argument. There's only been about 5 cases in the modern era that I'm aware of that in which they've asked for re-argument or set it for re-argument, and Murphy is one of them. So the justices are really struggling with this. A couple of the other cases are Brown versus Board of Education, Roe versus Wade, and the Citizens United case are all examples of ones they push for re-argument.
So this case, from a standpoint of attention by the court, ranks up there with those others you just mentioned.
Absolutely. And I think the justices are really struggling with it. If you apply the Solem and the Solem test and the Parker versus Nebraska tests, and just look at the clear text of the treaties and the statutes, it's a pretty easy case to decide that the reservation still exists. But I think a number of the justices, including Chief Justice Roberts, Justice Alito, and Justice Kavanaugh in particular, are very concerned with the practical outcome of this case and how it'll be applied.
Well, we got about 30 seconds. What's your prediction?
You know, it is really hard to say. I think that Justice Breyer could be a swing vote on this. If I was a betting man, I would say that if you apply Solem and Bartlett, Solem versus Bartlett and Parker, then the Creek Nation wins. The reservation is not disestablished. Mcgirt has his conviction reversed, and Murphy's case is affirmed.
And chaos ensues.
Well, I don't think we're going to have chaos, and I think we can work it out.
Mike, that's got to be the last word. Thank you so much for coming to visit with us about this important couple of decisions out of the U.S. Supreme Court. Thanks for all you do for Native American work in the state of Oklahoma. We'll be right back. You're watching The Verdict.
It used to be okay in hospitals. It used to be okay in movie theaters. It was okay in classrooms, restaurants, and airplanes. But thanks to a greater understanding of the dangers, that's not okay anymore. So now that we know secondhand smoke causes lifelong health problems, why is it still okay to smoke with children in the car? Bottom line, it's not okay. Let's get serious about protecting kids. Join the fight at stopswithme.com.
All children deserve a life of hope and love, but sometimes they experience a life of pain, neglect, and abuse.
When that happens, each child deserves all the quality assistance and representation that can be offered in our legal system. For more information, call 23-CHILD.
Oklahoma Lawyers for Children, helping to bring hope and love back to the lives of abused children.
You will always be mom and dad to me.
I really think people are so unaware of the number of kids waiting just in Oklahoma. And I think if more people knew that those children were out there waiting, I think that just by the way we live our lives and the people we talk to, that maybe we can help encourage adoption from Oklahoma.
You will always be mom and dad to me.
The Journal-Record is pleased to be a sponsor of The Verdict. The Journal-Record, since 1903, the best source of Oklahoma business news and legal information.
And welcome back to The Verdict. Kent Meyers with Mick Cornett, closing this show, talking about some very significant decisions in the Native American law area. What do you think, Mick?
Well, it does seem like the type of decision that could have repercussions that affect us, not only in the short term, but the long term. And you're always reminded of the very interesting way in which our state was established, and the way in which the state government and the American Indian tribes and their sovereignty had to be dealt with. If you'd like more information on Mike, you can get it at CroweDunlevy.com. That's CroweDunlevy.com. And of course, Kent, as I think our viewers know, our website is theverdict.tv.
Thanks, folks, for watching us today. We've enjoyed having you with us, and we'll see you next week. You've been watching The Verdict.